Mr. Walken?
No,
It's my turn first, I think, on this one.
I'm sorry, Mr. Tsoya.
Your Honor, this is Bar Counsel's appeal from a decision of the single justice. The single justice has imposed a public reprimand. Bar Counsel's recommendation from the beginning has been a suspension for a year and a day, and I suggest to you that that is
And I
the
take it that recommendation has not been adopted at any level.
That is correct, not at any level. But I present it to you because I continue to feel that it is the correct sanction. I'm not going to recite all the facts to you, but I would like to set out a few dates to make clear what it is that I say happened in this case. What happened was that Mr. Franchitto received 3 uncertified checks from a new client to conduct closings with. He deposited these checks in his IOLTA account, conducted the closings, and made disbursement, and payment on the checks was then stopped. So let us look at the dates that I want you to talk about. The 3 closings took place between June 15th and June 22nd. On June 22nd, Mr. Franchitto received the first word from Island Mortgage, the mortgage company, saying, "We have stopped payment on the first check, the cardinal check, and it was a clerical error, and here is a replacement check." 1 week later, Thursday, June 29th, Mr. Franchitto received word from his bank, not from Island Mortgage, that payment had been stopped on the replacement cardinal check and additionally on the second check, the Roy check, so that he knew at this moment, Thursday, June 29th, that his IOLTA account was approximately $550,000 short of what it needed to have in it. His testimony was, and the testimony was credited, that between June 30th and July 7th, and of course the 4th of July holiday comes between those 2 dates, he made repeated phone calls to Island Mortgage without success, without attracting any information from Island Mortgage at all, promises that calls would be returned, rumors from banks, from other people that there was a computer problem, but from Island Mortgage, nothing. And at the same time, he learned that New York had suspended Island Mortgage's license to issue mortgages. He learned that Massachusetts was about to suspend the mortgage. Every day, something happened that made this case worse, even if it was simply failure to respond from Island Mortgage. We come then to Monday, July 10th, and on that date, the last shoe dropped. The 4th check, actually, for the 3rd closing, was again dishonored because Island Mortgage stopped payment. The hearing committee found that no reasonable person, as of this date, Monday, July 10th, could possibly have thought that this was an error, that it was something that was going to be remedied. Any reasonable person, and Mr. Franchitto concedes that he is a reasonable person, that he had drawn this conclusion, knew that this was a serious problem. On this date, Mr. Franchitto knew that his IOLTA account was $800,000 short of the amount he needed to pay his debts to clients. Nevertheless, on the following day, Tuesday, July 11th, he conducted 2 additional closings. Now, he had done a number of closings in the intervening week, but those were in the weeks when he was still having his forlorn hope. During that week, he was still, with less and less confidence, thinking, well, perhaps this is just an error, perhaps it will be fixed. On July 10th, no one, and least of all Mr. Franchitto, could possibly have thought that this was an error that would be fixed. Nevertheless, he sat in 2 closings on the following day, and he said to the sellers in those houses, and I don't claim these are actual words, but he said by his conduct, by his status as a lawyer, by the normal understanding and course of business, this is a normal closing. Give me the deed to your house, and you will be paid. I will write you a check, and you will be paid. When he said these things by his conduct and by his status, he knew that they were false. And the hearing committee has found that this was dishonest conduct, as I think it must have found. The board had confirmed those findings.
Just as a matter of curiosity, doesn't that satisfy all the requirements for the bad check statute?
Certainly, it is a violation of the good fund statute.
But there's another statute. There's a criminal statute. If you write a check with insufficient funds and get something in exchange for it, it's attempted larceny.
I would have to look at the actual criminal statute. My memory is you do have to get something in exchange, and
you got a deed here.
And you have to write a check against funds that you know are not there.
Yeah.
So you may be right. It hadn't occurred to me before this moment, but I think you may be right that that would satisfy the felony portions of the criminal statute had the district attorney chosen to bring charges. The point I'm trying to make is that Mr. Franchitto's conduct throughout the week, but particularly on that Tuesday, was not innocent conduct. It was conduct that was deceptive, conduct that he knew would be a problem. He was, in effect...
Excuse me, does the record tell us how long he had worked with the Island Mortgage Network of Long Island?
Yes, it does.
How long?
This was his very first transaction with Island Mortgage of Long Island. What had happened is that he had dealt with a company called Bay Mortgage, approximately that name, based in Plymouth, Massachusetts. That company was acquired by Island Mortgage, and the very first transaction that took place under the name Island Mortgage was the Cardinal closing that happened in June.
How long had he been involved with the predecessor to Island Mortgage?
I know for a substantial period. I don't know the exact term.
Okay, thank you.
Among the people that he consulted during this week of trying to find out what happened were, of course, the principals at Bay Mortgage, asking them to find out what happened. He received some assurances from them, but those assurances proved false. Not that I'm blaming them, but what he was told, the money has been sent, you have received the money will be in your account, and it was not there. So that when he came to the money, it was not there.
What is the difference between this case and is it the Eskenazi, the Eskenazi?
I think a number of things have to be said about Eskenazi. First, Eskenazi was a settlement. Because it is a settlement for the facts recited. The facts recited in the settlement were that there was negligent misuse with no harm to any client. I think that is a distinct difference between the actual, and there's an attempt to look at the Eskenazi and say, well, really, if you look at the facts, it was much more than that. But it was a settled case, and the agreement was, these are the facts, and that's what they are. This case is much worse than that, because in the first place, it involves incredibly more money. Mr. Eskenazi was able to put the $10,000 in and solve the problem immediately. This is $800,000, which no one can put away. There was no deception to a seller, as there was in this case when we went to Mr. Roger Ames and to the two other people and said, give me your deed and you will be paid, when he knew they would not be paid.
Well, but they have been paid ultimately, haven't they?
They were ultimately paid, and the hearing committee justly noted that it was largely or partly through Mr. Franchitto's efforts that his insurance companies paid these sellers. And the way they paid the sellers is they took up the mortgage. The mortgage to Island was essentially canceled, and they took another mortgage from the buyers on the same terms and used that money to pay the sellers. So things did work out. They did work out after 4 to 8 months, during which these people were deprived of their funds. Now, what is the appropriate sanction for this? I suggest to you that you should look at the Schoepfer line of cases, which you have reaffirmed as recently as yesterday, that the normal sanction in the Schoepfer case, so in a misappropriation case, is a suspension of appropriate length. Now, the touchstone sanction in this case would be an indefinite suspension. We have never asked for that. The sanction that we are asking for is a year and a day. And that is particularly appropriate because of the fact that Mr. Franchitto has previously been disciplined by suspension. So if anything, the normal sanction should go up.
Well, the Eskenazi case, is that likely to reoccur?
I'm not sure I understand what you mean by occur.
Will Bar Counsel, is Bar Counsel likely to agree to a settlement in a case using Ashkenazi as precedent?
It's very difficult for me to predict what Bar Counsel will do. You know, I'm not the person in authority. In fact, there's no person in ultimate authority at this moment, as you know. But I think that that's a lesson that has been learned, that perhaps this case was let go too cheaply. I don't know whether that's something you can legitimately take into account or not. But, you know, you can scarcely come and say Mr. Franchitto should be suspended, and then, again, the next time something similar happens, say, well, we won't ask for a suspension in this case.
Mr. Sawyer, one last case, because I see your question, I see your time up. I mean, the single justice, looking at, you know, Schopfer on that line, said that this case did not involve the intent and repetition that those cases did, and that she characterized, accepted the words of the board as lapses of judgment made under stressful circumstances, and that's why she pushed them towards Ashkenazi. What's your response to that?
I think that the distinction that the single justice drew is an invidious distinction, one that should not be permitted. If it's an entirely different thing to say that, all right, I have looked at the Schopfer line of cases, and I'm just not going to do it because it isn't right in this case. But the distinction that is purportedly drawn should not be supported, because there have been, in fact, cases that have imposed suspensions without commingling. There have been cases that have imposed suspensions for robbing Peter to pay Paul without any money actually going into the lawyer's pocket. And it would not be a good idea to change that rule in the Schopfer case. All cases are individual, as, of course, the Court has repeatedly said, and the single justice was expected to exercise her discretion in this. I believe she has made a mistake, but if she directly confronted it and said, just, I'm not going to apply this case because it should not be applied, the Schopfer case, because it should not be applied in these circumstances, that's what she gets paid to do, even if she's wrong.
Thank you, Mr. Sawyer. Mr. Walken?
Thank you. May it please the Court. Robert Walcon, representing the respondent, John Franchitto. John Franchitto, Your Honors, was the victim of a crime perpetrated by one of his clients. It was a nationwide banking conspiracy during which he had to make some very difficult judgment calls while he was being deceived into believing that this was a simple bank clerical error, which is fairly common in conveyancing practices, and continuously being reassured by banking officials, government officials, and attorneys that the funding error was legitimate and was going to be promptly rectified. This is not, by any stretch of the imagination, a misuse of funds case, and that's precisely why the single justice and the board and two previous panels of the board before them put this in the category of a good funds statute violation, because that's exactly what it was.
You know, we have a lot of cases where people walk into a convenience store and write a check, and they'll get a bag of potato chips and maybe a pack of cigarettes, and there's no money in the account, and district attorneys prosecute these people for a bad check.
Right.
And sometimes these people go to jail. But why doesn't this situation fall into that category? Why isn't this a violation of the bad check statute?
For several reasons. First of all, there was plenty of money in Mr. Franchitto's IOLTA account. This was an attorney who had a high-volume conveyancing practice running an average of $5 to $6 million of an average daily balance. So he had money in the account. This was not a situation where a lawyer showed up and knew, as was the case in Ashkenazi and the admonition case 0212, both of which are cited in the single justice opinion, that there was no money in the account. This account had plenty of money in it. What's more...
Let me just stop you. Remember your what's more point, but does that mean that at the time he proceeded with the closings that there was adequate money?
Absolutely. There was adequate
did the
money.
check-
It was somebody else's
It was
money.
somebody else's.
Money from other closings.
Actually, it wasn't, and there's my what's more.
Okay.
Wait, did this check clear?
Which check?
The check that was given in exchange for the deed to the house.
In which closing? Are we talking about the July 11th closings?
Yeah.
Okay, so I'll try to wrap all three of these comments together. The island events occurred during the 4th of July holiday week. On July 7th, which was a Friday, Mr. Franchitto was personally assured by the president of Island and the vice president that replacement funds were going to be wired into his account. And in fact, they said that the funds were wired into his account. He checked his account on July 10th, the following Monday, and those funds were not there. That brings us to the two closings that Bar Counsel claims is the smoking gun on July 11th. Mr. Franchitto wakes up in the morning and he checks his account to see if the Island replacement funds had been wired in, and unfortunately, they were not. The problem is that funds from two unrelated closings were in fact wired into his account the previous night, and those were the funds for the two closings that were scheduled to take place that day. So the answer is, not only did he have other funds, other people's funds in his accounts, but he had the two closing funds, $600,000 or $700,000, that were earmarked specifically for the two closings that were scheduled to take place that day.
From other banks.
From other banks, completely unrelated to Island. And there's where the dilemma comes in. That was the judgment call he had to make. What do I do? He felt that he had legal and ethical and fiduciary obligations to his clients, those other lenders, and to the people who were going to be sitting at the closing table that day, moving trucks in the driveway. They were going to be using those closing proceeds to close on other homes. He felt that he had a legal and fiduciary obligation to take that money out of his IOLTA account and disperse it to those parties. And that's exactly what he did. The money was not his. And he felt the best way to safeguard it in light of what was going on with the Island mess was to get that money out of his account and into the hands of those people who were sitting at the closing table.
So on that day, he still thought Island was going to come through.
As of that day, he had been told that the wire had already been sent to his account from Island.
So he's thinking that, well, they've been wrong before, it's another clerical mix-up.
No, he was distraught. I mean, I'm not going to sit here and tell you he wasn't in a complete panic at that time. But
Did he have any right not to distribute the funds if you are telling me that the funds came from another bank in connection with an unrelated closing?
No, he had no right not to distribute those funds. He was under contract and under a legal obligation to disperse those funds to the borrowers who were sitting at those closing tables. And that's why he did it. Had he shut down the account or had he left the money in the account, that's where the money would have been at risk of being drawn on by unrelated parties, not by these two parties. What he wanted to do was lift that.
Well, these two parties then, what you're saying, had ordinary, clean closings, in the sense that the deed was swapped and the money was there from the other bank.
As it turns out, what happened was he dispersed the money to those parties. One of those parties, and I believe it was Mr. Ames, did not negotiate that check immediately. He got out of those closings, he checked his account, and the Island wire had not come. That's the point at which, and that was the first time at which he said, I give up hope. I don't think, I've been deceived. I don't think this wire is coming. I've got to shut down this account. And that's why Mr. Ames's check bounced. Had he shut down the account one day earlier or not used those funds, we wouldn't be talking about Mr. Ames, but it would be Mr. Smith or Mrs. Jones or somebody else. But what he did was
even though he had enough money in there to pay Mr. Ames.
That's right. Had he been dishonest,
another bank's money.
Had he been dishonest, he would have kept the float going. He could have paid Mr. Ames. He could have.
The float pertained to the other closings where the Rhode Island money was supposed to come in and didn't.
This was an attorney who had about $5 or $6 million in his account.
I see. So there's a little floating going on no matter what.
A lot of floating.
A lot of floating.
If he wanted to be dishonest, he could have kept this account going forever. Bar counsel never would have even found out about it. Okay? He did the right thing. He shut down his account. He contacted federal and state banking regulators. He self-reported to the bar, to the Board of Bar Overseers and to Bar Counsel. And then, knowing that there was going to be a problem, he went and sought a personal loan for $800,000. He wanted to go into his own pocket to try to prevent what he knew were going to be bounced checks coming out of his IOLTA account.
When did he first learn that the Rhode Island Bank was engaged in a giant criminal conspiracy?
It wasn't until weeks after, and it wasn't Rhode Island, it was Island,
Well,
Long Island.
Yeah.
But What happened was several days later, Island filed for bankruptcy, and several weeks later, news of the arrests and subsequent criminal
On
indictments were
July
handed
11th,
down.
he knew something was really fishy, though, with Island.
What he knew was that he wasn't getting proper responses from Island, but he had been assured. What changed on July 11th, on that Friday, was that he had conversations with the president and
Monday.
vice president of Bay
On the Friday or the Monday? The 7th was the Friday.
on the Friday.
Oh, the following.
Isn't it?
Instead of people promising we're going to send the money, they said, we sent it. And furthermore, he received another assurance, separate and apart from these from Island, from an attorney who he knew in Boston. It was attorney, now Judge Lloyd McDonald, and he called Attorney McDonald and he said, I've got this problem, what do I do? And Attorney McDonald called him back and said, I'm sorry, I've got good news and I've got bad news. The bad news is I can't represent you because my law firm represents Island Mortgage. The good news is I did look into this and I found out that this was a clerical error. Their computers crashed in
So
the course.
he's getting scammed, too.
McDonald?
Yeah.
Yes, absolutely.
But isn't it axiomatic in real estate practice that you don't do anything until the money's in the account? You don't do anything. You don't complete the transaction till the money's in the account.
That's right. The transactions that he completed on July 11th,
No, the prior transactions, had there been
Island.
prior transactions for which Island said there's supposed to be money, but there wasn't?
they had sent 3 checks. His paralegal got those checks. He had very strict office policies to comply with the good fund statute. His paralegal got those checks. They had bank security marks, watermarks on them, very similar to bank and certified checks. She put those checks into the account, and the record shows that he never saw those checks when they went in.
And they bounced.
No, they didn't bounce. He went and did the closings. Subsequent to the closings, it was 7 or 8 business days later, Island stopped payment on those checks.
Oh, stop payment.
So he went into those closings in June with, in
The
his
money.
mind, appropriate funds.
So,
Island committed the fraud on him after the closing. That was the nature of their scheme. They did this to attorneys all over the country. They
so in
sent
other
the
words,
money and then stopped payment on the checks.
He closed appropriately in June. By early July, they had stopped payment. He recognized that there had been a closing where the monies were now not available to pay, notwithstanding his paralegals depositing of what appeared to be valid checks, and in fact checks in any event. And that's what caused the beginning of the run?
That was what caused the beginning of the run.
Well, the run would have happened eventually. It would have been caught sooner or later, right? Because he's got this glaring $800,000 hole in his account.
Not
But
if he
you
was-
can't keep floating forever.
Well,
He would have covered it with his own personal
he
funds.
could have covered it with his own personal funds, or maybe had hoped that his
How could he
insurer,
do that? He
his-
tried to
or-
get a loan, and they wouldn't give him a loan.
or his insurer could have put the money back in if he was dishonest. But he wasn't dishonest. What he did was he tried to do the right thing, and he said, I've been defrauded, I've got to shut down this account, and I've got to face the music. And then what he did was he worked tirelessly for weeks after this with his title insurance company to make sure that every single payee of a check, whether it was a municipality, taxing authority, credit card companies, any of the
But
hundreds
when
of
he, when he
people.
went ahead with those 2 closings, there, he knew that there was no money in the account.
No, there was money in the
No,
account.
there was plenty of money. There was hundreds of thousands of dollars in the account from
And then they began.
2 wires had come in the night before
Yeah,
for those 2 closings.
yeah.
And that's exactly what he used. He felt the best way to safeguard that money for those people was to get it out of his account because he knew that there was a problem with the Island money. And if he just...
I'm not even, I don't know the facts, but I'm not even sure that he had any right not to close on those properties.
He had no right not to close. He had to close.
Very unusual facts, very unusual.
Very unusual, very sad facts. His practice and his life has been turned upside down for the last 6 years. He had to close his office and lay off all of his staff. He still practices out of his home, and he lost all his business as a result of this. He's very, very distraught over this. I see my time is up. I would like to make the court aware of a brand-new case that just came out. That
Why don't you send a letter? post-argument letter and send a copy to Mr. Troyer.
I will do that.
And you can do that within a nanosecond.
Okay. Thank you for your time.
Thank you, Mr. Walker.
All rise.